Hello, everyone.
Hello.
Hello.
Y'all hear me?
Yes.
Yeah. Yes.
Yeah.
All right. See here. I see Quadesia Sharp on the list. Liam,
Yes.
Liam Moore. And I'm just going on what I see on the side.
Thank you so much. I know they left me hanging.
Professor Boyce, were you calling my name?
Who's that?
Liam.
No, I was just checking you was here because I saw you sign in. So I'm trying. Probably because people keep signing in, it's hard for me to keep track of the list. I'm just gonna call names out alphabetically.
Oh, okay. Thank you.
So, all right.
Did you get Ebony Chavis?
I haven't got there yet. I'm just calling names out real quick.
Oh, okay.
I was trying to just click on everybody as they signed in, but that's a little bit harder because everybody signed in. I gotta actually let people in. So every time they come up here, I gotta stop doing what I'm doing to hit admit. So that's gonna be a little bit hard. Yeah, somebody else coming in. There we go. Glad everybody here though. At least y'all want to be here. I ain't mad at it. Okay. All right, I'll just call the names. Jamari Adams. Nadia Bell. I see.
Here.
Okay. Samaya Blunt.
Here.
Tierra Brady. Antonio Brown. DeAndre Burgess. I see you. Jamez Burns. Am I saying it right? I don't think it's James. I think it's Jamez Burns. Ebony Chavis. I think you said something earlier.
Here.
Right? All right. Jada Ellerby.
Here.
All right. Shanae Ewing. Or Shania Ewing. Miss Ewing. All right. Abby Feith. Or Faith. I can't, however you pronounce it. All right. Alexis Fields. I see you up there.
Yeah.
All right. Brandon Foster.
I'm here.
Jalen Good.
Here.
Sydney Graham.
Here. Here.
Tavia Hawley. Kiswana Houston. Oh, sorry, you come.
Here.
Got you. Okay. Kiara Jefferson.
Here.
Aaliyah Johnson. Aaliyah Johnson. Robert Jordan, I see you. Sierra Knox. Sierra Knox. Kevney Lomax. Lomax.
Yes, sir. I'm here.
Lisa Maldonado. Lisa Maldonado. Sincere Mays. Sincere Mays. Nasir McDaniel Moore.
Here.
Brandon Merritt.
Here.
Terry Miles. Terry Miles. Mary Monroe. Mary Monroe. I already got Aaliyah Moore from earlier. Ariel Moore.
I'm here.
All right.
I'm here. Did you hear me? I'm sorry.
I got you, Miss Moore.
Okay.
Daniel Moore.
I'm here.
Aaron Orr. I think I saw you on the screen as well. All right, see you.
I'm here.
Ramia Parker, or Ramia Parker. Parker.
I'm here.
Is it Ramia?
Yes, it's Ramia.
All right. I think this is Mary checking on now. I just called her name. Is that Mary Monroe that just signed in? Mary Monroe. Okay, Mary's iPhone. Oh, she's connected. Hold on. Mary, is that you that just signed in? Mary Monroe? Hello? All right. I got you. All right, sound a little bit robotic. Probably bad signal. I got you.
Okay.
All right, now where was I? Just left Ramia. Asia Pennick, I'm sorry. Pennick.
Here.
Kiera Porter. Porter. No Kiera Porter. Raven Rayner. Raven Rayner. No Raven Rayner. Gabrielle Rodriguez.
Here.
I already got Cordesia Sharp earlier. Tamara Sheely or Shelley. All right.
Tamara Shelley, I'm here.
Shelley, okay. Ariel Sherrod.
Here.
All right. Simone Tunstall. Tunstall.
It's Tunstall and I'm here.
Jeremy Vick. Jeremy Vick. All right. Kerry Watkins. Kerry Watkins. No Kerry Watkins. Talika Yates.
Here.
All right. Alana Young Maddox.
Here.
And Carmen Town. Are you still on here? Sorry, no Carmen Town. Look, I didn't see you on my updated class roster, so I'm figuring you might have been in the wrong class or signed up for the wrong what's it called, a Zoom. All right, anybody I missed? Anybody not sure their name got called? Okay.
Mr. Boyce, did you get me? I'm sorry.
What's your name?
Kiera Jefferson.
Jefferson?
Yes.
Yeah, I got you.
Okay, thank you.
Anyone else? Okay, cool. See what we're talking about tonight. Okay, tonight is the 8th. So let me make sure I want to make sure you guys are apprised of anything that might be coming up. I think everything's good. This is Zoom discussion number 3. No assignments coming up. Your first quiz isn't until the 22nd, so you got a minute before that comes up, a couple weeks. The last reading assignment, that you were supposed to read before tonight would have been chapters 3 and 4. And I posted my lectures as well. Did everyone understand the lecture, and are there any questions?
Yes, I understood. No questions.
All right. So of course, just to go over briefly what chapters 3 and 4 are about. So I know it's kind of redundant because I already gave a lecture and you were supposed to read as well, but just to make sure everyone is good and there's nothing else to be covered. Chapter 3 was about the types of law. That I remember, I know we talked about civil law and criminal law. Of course, civil law being a person versus a person. Somebody else signing in. Hold up. Aaliyah Johnson, I just got you on the roll. You good? Aaliyah?
Okay, thank you.
Okay. What I was talking about, chapter 3, types of law. Of course, the two main types of law we talk about all the time. The two main sectors of law. This is somebody else raising. Raven what? What's your last name? Make sure
Rainer.
Rainer, hold up. I got you.
Okay, thank you.
All right. All right. So what was I saying? Yeah. Chapter 3 was pretty much about the types of law, primarily 2 types of law: criminal and civil. Civil is when someone sues another person. So it's an individual's interest versus another individual's interest. Let's say if it's a breach of contract or something like that. If me and Aaliyah Moore have a contract where she's supposed to render a service or good to me in exchange for my money, and I pay the money, and then the service she rendered is either unsatisfactory or she fails to do so. So now I want my money back. So I file a lawsuit. That means I want my money back for. Okay, Aaron, I see your message. All right, sorry about that. But what that essentially means is I'm suing her for my personal interest. It's me versus her. That is civil law. And normally it involves either money or either money or some type of what we call injunctive relief. So sometimes the court, even the civil court, instead of asking for money or making a person pay money, they can actually force the person by court order to do something or to stop doing something. So has anyone ever heard of a cease and desist? When you get that letter in the mail or something, or you get served with a cease and desist order, which says stop doing what you're doing. That is a form of a civil lawsuit where someone has now filed an action against you to try to get the court to stop you from doing something or to force you to do something. A lot that's all. Civil law also includes child support and child custody and stuff of that nature. Those are all. That's also under the civil umbrella. So when someone files for custody or to get visitation, that is called a complaint, a custody complaint. It's filed in civil court. So it's essentially asking the court to demand this person to give me my child, or so that starts. So it essentially in child support court, or not in child support court before we even get there. In child custody court, you have one parent that sues the other parent, files a complaint against the other parent, and is served by civil process, and they have to come to court and settle it. Then at some point in time, the court either settles it or they settle it. They have an agreement, and that now becomes the child custody order. So that's also civil. So it's always a personal interest versus another personal interest. Because of that, because there's no one's going to jail. Now you can be brought up on contempt if you fail to comply with the court. But just because you're found in contempt does not necessarily mean that the court has to put you in jail. So because the stakes are not as high, the burden of proof in civil cases is much lower. It's what we call preponderance of the evidence. So in other words, mathematically, that is 51 to 49. So if you can prove that it's more likely than not that what you are asserting happened, then the court would render a verdict in your favor. And in the civil court, we call it, we don't call a person guilty, we call them liable. And liable or liability is nothing more than a fancy word for responsibility. So sometimes you hear me say that in the criminal setting as well. You hear me say criminal liability. What criminal liability means is criminal responsibility or guilt. But normally you're not supposed to kind of mix the two. Liability is just supposed to be for civil, and we don't usually use liability. But here and there, I got you, Sharnae. Here and there, sometimes we kind of use them interchangeably. But you always hear me say if it's talking about criminal responsibility, you always hear me put the word criminal in front of liability before I use it. So just know if you ever hear me say criminal liability, that just means guilt. So if I'm saying is this person criminally liable, that means is this person guilty? Or what, if anything, would this person be criminally liable for or liable for? And this is a criminal class that I'm essentially asking you what, if anything, this person is guilty for. So I want you to be able to know how they're used. I don't usually like crossing them over, but sometimes I do. But on the criminal side, however, which is different from the civil side, it's not a matter of an individual versus an individual, or an individual interest versus another individual interest. It is a matter of society as a whole bringing this one individual to court because they have violated that contract. And I know y'all remember that from my lecture, but they violated that contract between society and every individual. So what laws are nothing more than agreed upon, an agreed upon code of conduct between society, between everyone in society. So when you break a law, you're essentially breaking that code of conduct between you and the rest of society. That's why when you go in front of a criminal court, the case is always the state versus or the people versus. Because you're being brought before the people to either say why you did something or that you didn't do it. So prove that I did it if you think I did it. If you're accusing me, prove it. So in criminal court, of course, the stakes are much higher. It's not just a matter of money. Sometimes sometimes money is at stake because you can be forced to pay restitution or something like that. But it's more than just money in criminal court. there's also your freedom. So because there's more at stake, like your freedom, the burden of proof is much higher. So for the state or what we call the government, the attorney for the government, the state, or the people, to prove that you are guilty, then they must prove it beyond a reasonable doubt. And beyond a reasonable doubt essentially means pretty much 100%, or what I would say 99.9%, with at least 99.9% certainty that you committed the crime. So in North Carolina, our jury instructions say that in order for a jury to find someone guilty beyond a reasonable doubt, they must the person must be found, the jury must be fully satisfied and entirely convinced of the person's guilt. So you hear the words fully and entirely. So those are unequivocal words, right? So we talk about words that, so if something's full, there's no more room, it's 100%. If you get something in its entirety, you're getting 100%. So pretty much 99.9 or 100% certainty in criminal cases. So that's what beyond a reasonable doubt is. So as defense attorneys, of course, we're trying to find that doubt. Of course, reasonable doubt is not just in doubt, any doubt. It's doubt that's based upon reason. So I can't say my client didn't do it because the aliens did it, because that wouldn't necessarily be reasonable. That is doubt, but it's not doubt based upon reason. So my theory in defending my client must be based upon reason. So for the jury to find my client not guilty, that means they weren't fully satisfied and entirely convinced that my client committed the crime. So of course, the burden of proof in a criminal case not only is the burden of proof beyond a reasonable doubt, but the burden of proof rests upon the prosecution. In a civil case, the burden of proof rests upon the plaintiff. So the parties in the civil case is plaintiff versus defendant. In criminal case is the state or the prosecutor or the government, maybe or the people versus a defendant. So of course, the name of the parties doesn't change for the defendant, but it does change when it comes to between civil and criminal when it comes to the plaintiff and the prosecutor. So the plaintiff has in the civil case has a lower burden, but they still have the burden of proof. So also in civil law, a person can answer a civil lawsuit by denying everything, or not only denying but also filing a counterclaim against the plaintiff. So both parties can become plaintiffs in civil cases where now they're suing each other. So we'll call them pretty much cross lawsuits or counterclaim lawsuits. So either way, if that happens, both parties have the same burden of proving liability by preponderance of the evidence in civil case. So either way it goes. In criminal court, there is a such thing as cross warrants, where one party's charged for committing a criminal act, and the other party's also charged for committing a criminal act against, so they're charged. In that situation, there's still one prosecutor that's in charge of prosecuting both of them. There are certain situations where a defendant that's also a victim can actually hire an attorney to prosecute the case. We call it private prosecution. So by virtue of hiring an attorney or having an attorney appointed, that attorney can now turn into the prosecutor in that other case. And normally when that happens, normally for us as attorneys, when that happens, we defer to the prosecutor and we ask them to prosecute both cases. So they have the duty to prosecute my client and the other person in that situation. So they're allowed to pick a side, but they're not really, they really are supposed to represent the interests of the state. So the state doesn't actually have a client. The state represents the interests of the people. Yeah, I'm trying to make sure I got covered everything. So that's the difference between civil and criminal. Sometimes an act that is wrong in criminal law can also be wrong civilly, meaning the same action can also lead to a lawsuit being filed. An example would be O.J. Simpson. He was charged with the murder of Nicole Brown Simpson and Ronald Goldman, and the families also filed a lawsuit for wrongful death, which essentially is a civil action saying your actions caused the death of our loved one, and now we want you to pay us for it. So essentially, they sued him for wrongful death. So of course, because the burden is much higher in the criminal court system, he was found not guilty in the criminal court. But on the civil side, remember the burden of proof is much lower. Because it's easier to prove in the civil case, he was found civilly liable for the wrongful death of Nicole Brown Simpson and Ronald Goldman. So he won the criminal case, which meant he got to go free, but he lost the civil case, which means now he owes money. There's a big civil judgment. It was somewhere in the millions of dollars that he was ordered to pay by the court for the wrongful deaths. So because of that, that's actually what landed him in jail later on, because he didn't necessarily have the money to pay the civil judgment. So because he couldn't pay the civil judgments, they essentially executed the judgment against him, and he had to kind of liquidate all of his assets. So at the same time, he's trying to pay his very high cost attorneys. He had a pretty good legal team, so he had to pay them, and he also had to pay that money in the judgment. So he had a lot of money to pay. So a lot of things were taken from him. Stuff like his, if y'all know O.J. Simpson, he was a college football player and an NFL player, but in college he won the Heisman Trophy. So they took stuff like his memorabilia, which was worth a lot on the market. His Heisman Trophy was taken, stuff like that. So fast forward 20-something years later, he's now trying to get his stuff back. But of course, because there's an outstanding civil judgment and it hasn't been paid, pretty much every time he makes any meaningful money outside of like a pension, some of that money goes to the family of Nicole Brown Simpson and Ronald Goldman, because there's a judgment that still has to be satisfied. So of course, he couldn't kind of, flaunt his money, but he had some money on hand and he wanted to get some of his stuff back that had been auctioned off. So of course he couldn't roll up and get it himself, so he had to hire someone secondhand to get it from him. Of course, these people he hired were kind of mob bosses, the kind of people that were on the low. So they get his stuff for him. He's coming to pay it, and they kind of try to lowball him or screwball him and say, "Nah, we want more money for it." And he's like, "We already had an agreement. I've already paid you. I'm coming to get my stuff. I'll be there in 5 minutes." Of course, when he went there, because he was dealing with some underhanded guys and make, which he shouldn't have done, but he was dealing with some underhanded guys to get his stuff back, he bought muscle. Of course, you don't go into a situation like that because, as the mobsters say, you can get whacked, right? So he goes in it with some muscle just to have somebody having his back in case these guys try to stiff him for real. So he walks in with his muscle. An argument ensues because they're kind of refusing to give him his stuff, even though he's already given them money up front. So as the argument ensues and he's like, "Give me my stuff," he said, "I'm the juice," of course. Anybody that's looked at the case. But one of the guys behind him brandished a gun. In other words, one of the security people on his muscle detail kind of pulled up his shirt, was like, "Yo, give my man his stuff or it can go down." Of course, OJ wasn't actually personally carrying the gun himself, but somebody on his team was and showed the gun. And I don't even think OJ saw the guy because the guy was behind him, but the guy brandished the gun. At that point, it went to another level. They gave OJ his stuff back, and of course, those guys they were mobsters, so they had guns too. But they gave him his stuff back, and then they tried to say he robbed us. So, because the technical definition of a robbery, armed robbery, is to take something by force or by threat of with a deadly weapon. So that's armed robbery. So they tried to say, "Oh, he robbed us," when in actuality, no, he was going to get his stuff. So of course they played it out, and all this funny business happened. And then you had an overzealous prosecutor who was not involved in because this has been a whole different case. The O.J. Simpson murder trial was in California. This was in Nevada. So he ended up getting convicted, and of course the prosecutor was going all the way in because it was a chance to put OJ down, right? For this murder they say he got away with. So of course, in that situation, the prosecutor over prosecutes it because he just everybody wants to say I was the one that took OJ down. So OJ gets convicted because technically, you know, even though you're going to get your own stuff, if there's a weapon brandished, even though OJ didn't have a weapon himself, it's essentially conspiracy to commit armed robbery. So even though that sounds totally dumb, he got convicted of that. And I think he did a few years in jail and ended up getting out on parole recently. I think like last year or so he got out. So he's out now, got out. And actually at his parole hearing, one of the alleged victims came and actually kept it real and said, yo, you know, like, don't have a problem with OJ. He was just essentially coming to get his stuff. So it really makes the prosecutors look stupid because you can tell they were overdoing it just to get OJ. It had nothing to do really with the facts in the case. So that's just an example of OJ getting both charged with the crime and being sued for the same action. And then we fast forward 20-something years later, got him in trouble again because he just couldn't let go of his stuff. He wanted to get his stuff back. So that's OJ Simpson's life, y'all. So that's how criminal and civil law can merge, and I want you to know the difference, of course, between the two. Then we have chapter 4, where we talked about court organization and structure. I know you guys learned via my lecture and through your reading. I know you guys are reading, but you guys learned that, of course, the court system, the federal side of the court system, was created by Article 3 of the United States Constitution. So, of course, the federal courts would be younger than the state courts because, of course, before we had a country, before we had a constitution, we had 13 colonies. They had governors that were appointed by the king, and so they already had at least colonial governments in these different where they weren't states then. They were just provinces or colonies. So you had the 13 colonies that already had courts. As a matter of fact, here in Guilford County, anyone that's ever been on Battleground Avenue, there is a military battleground site where there was a battle fought in the Revolutionary War. That's actually why this city is called Greensboro. It's named after Nathaniel Greene, who was a general for the U.S. Army when they fought Britain. And actually, one of the turning points of the war were some of the battles that happened here in North Carolina. Here in Greensboro, then also there was a battle in Kings Mountain, but that kind of changed. Those battles kind of changed the pace of the war because we were fighting Britain. They were the biggest power, so that's why our city's named. But the battle is called the Battle of the Guilford Courthouse. So before Greensboro wasn't even founded as a city until 1808. So a few years after, maybe almost 20 years after the Revolutionary War, Greensboro was founded. But there was already a Guilford County courthouse. So that lets you know historically there was already a court system here before we became a country. So the court system that was created after we became a country was then the federal court system. So of course, the way the country was set up, they created a federal court system. And of course, our Constitution and our court system is nothing more than evidence that there was a great compromise. You had some people that wanted a centralized government and the federal government to kind of be over everything, and you wanted some people that didn't want it to go back to being ruled by an iron fist or a king, that wanted the states to have their own rights and their own ability to do things as sovereign states. So of course, in that compromise, they created two court systems. You have the federal court system, and then each state individually had its own state court system. There's certain things that you can be charged for under federal law and be brought in the federal court, and there's certain things that you can be charged for in state court, and that still happens today. As a matter of fact, there's some things that are illegal both federally and on the state side, and sometimes the state will have charges filed against my client, and the federal courts will as well. A lot of times, the state will defer to the federal court. They'll drop their charges once the federal court takes over the case and files an indictment. But they can be charged in both jurisdictions. So, But the criminal court, the court system on the federal side was created by Article 3 of the Constitution. It created at the time, of course, we only had 13 colonies and we didn't have a very big population in America. So there were no courts of appeals. Essentially, there were like, they created federal trial courts. And then from there, if there was an appeal, it went straight to the United States Supreme Court, who at that time, I think they only had either between 3 and 6 justices. It wasn't even 9 yet. Later on, of course, they changed things. And of course, as America got bigger, we got more states, we got more people. They created an intermediate level of appeals courts called the district courts of appeals. And then they separated the states geographically into different districts, or what we call federal judicial districts. So North Carolina, this is food for thought. Well, for your information, it may come up on an extra credit question or something, but North Carolina lies within the 4th judicial district. So so it's us, Maryland. It says us, Maryland, Virginia, Ohio. No, not Ohio. Tennessee, I think Ohio. So it's pretty much that block of states right there, including Virginia, I think, as well. But I know I can't remember exactly. I think it's 5 states, but I can't remember the other 5 states, the other 4 states. But North Carolina is in the 4th judicial district. So if there's a federal case in North Carolina in criminal trial court, or even civil trial, even civil federal trial court, and someone wants to appeal, when it appeals, it's going to go up to the next level to the 4th district or 4th circuit court of appeals. From there, when it goes to the 4th circuit, it can be appealed from the 4th circuit. Then it goes to the highest court in the land, which is the U.S. Supreme Court. Then it goes there. So that's kind of the hierarchy on the federal side. You have your district court, which is the trial court, where they're determining guilt or innocence in criminal cases, or they determine liability or no liability in civil cases. Then they can appeal up to the next level. The next level is the circuit courts. From the circuit courts, if there's another appeal, it goes to the Supreme Court. Now, the Supreme Court of the United States does not automatically have to take appeals. They have discretion over whether they take a case or not. So it's not like they're duty bound to take a case. Now, when something's appealed from district court to one of the circuits, normally the circuits have to hear it. But from there, if it goes up further to the United States Supreme Court, the United States Supreme Court does not have to hear it. They have discretion. If they decide to hear the case, it has to be voted on. Of course, they're 9 justices now, so at least 4 of the justices have to vote yes that they want to hear the case for it to even come up. If they get 4 justices, 4 out of the 9 justices say yes, we want to hear it, then they grant what they call a writ of certiorari, which says we're going to hear the case. Now give us the documents, and we want give us everything we need to review the case. And then they set a date for hearing, where they're going to listen to oral arguments, and that they're going to determine the outcome or determine what's going to happen on the appeal. So that's how that works. But they don't have to hear everything, and really they don't. I mean, 90+% of the cases that try to appeal to the United States Supreme Court are turned away. So they only want to hear those major things. So if you see a case in the book from the Supreme Court, it must have been pretty serious because it got to the Supreme Court, and they decided to hear it, because normally they turn most stuff away. So that's the federal court system. In the state court system, the only state I can really talk about is North Carolina, because it's the only state I have a knowledge of when it comes to how the court system is made, the different levels or the hierarchy. Much like the federal court system, you have your district level of court, which is your trial court, and there's like one level below, which would be like in civil court, your small claims, and in criminal court, your magistrate's court, stuff like that, whereas small level matters, sometimes like traffic tickets and sometimes worthless check charges, are handled in magistrate's court. From there, of course, they can appeal up, or if it's a more serious charge like a misdemeanor or something like that, it starts off in trial court and district court, and then it works its way up if there's an appeal to superior court, which is the next level of trial court in North Carolina. So superior court has original jurisdiction over felonies, and it has appeals jurisdiction over misdemeanors that are appealed up on the criminal side. So it doesn't necessarily work that way on the civil side. On the civil side, in district court, if there's an appeal, that appeal is going to go straight to the Court of Appeals. There's no new trial. So, but on the criminal side, if there is in district court, if there's a misdemeanor trial and let's say a defendant loses and they don't like the outcome, they feel like their constitutional right was violated, they can appeal to Superior Court. And when they appeal to Superior Court, which is the next level of trial court, then they get a new trial. Essentially, they automatically get a new trial where now they get to try their case in front of a jury. In which case, of course, they win. The judgment of the jury, the judgment of the court is the judgment of the court. They can also choose to remand and take it back down and accept whatever happened below. Or they can, the new trial, they can be found guilty again. It kind of is what it is. They can't appeal. But at that point from Superior Court, when they appeal, is no longer a new trial. It's going up for judicial review to determine constitutionality and whether something was done wrong. But it's not a new trial. It gets reviewed, and it goes to the state. In North Carolina, it goes to the state court of appeal. From the state court of appeal, the next level is the state Supreme Court. Once it goes to the state Supreme Court, if it's a matter of federal law or the federal Constitution, or there's some serious, federal constitutional right that's in question, you can actually from the state Supreme Court, you can actually appeal to the United States Supreme Court. But they're only going to take the case if it's a serious question of federal law or the federal Constitution. And once again, like I said before, they have discretion over whether or not to take it. So a lot of important cases. Now we don't do a whole lot of case stuff in this class, but when you get to other classes like criminal procedure, criminal law, a lot of those cases they started in state court, and because there were such serious questions of the constitutionality of some police action, the United States Supreme Court decided to hear it. So they granted certiorari from a case that came out of the state court. So cases like Terry v. Ohio, that started out as a state court trial, and it went all the way up to the U.S. Supreme Court. And that's actually the case that created stop and frisk. So that's just one groundbreaking case that started in state court, worked its way all the way up, and got to the Supreme Court. But normally the United States Supreme Court is not going to take a case until every level of state court everything has been exhausted. So you're not going to appeal straight from trial court and state straight to the United States Supreme Court. You got to go through every level of the state before the federal Supreme Court is even going to want to even think about granting certiorari. So that's just a little bit about the organization of the court system on the federal and state side. Of course, every state is different. So you're also going to learn in this class a measure of civics, so the book is really heavy on the Constitution and what the Constitution did and didn't do. So that's why we know Article 3 created the court system. So I want you to think of the Constitution, think of America, and you've probably heard this before. America is nothing more than a corporation. It's a corporation where a whole bunch of smaller corporations have agreed via contract to bind themselves together and create this federal government. So the Constitution is what binds the other 50 states. So that's what we fought the Civil War over. So the Civil War was a fight over those who wanted to break the contract between the United States and themselves. They wanted to separate and say we no longer want to be a part of the contract, and that's what started the Civil War. So the Civil War is about no, you are going to be a part of us. That we have a deal, and we have sovereign. We have this contract. So each state has its own sovereignty in handling law in the state, but the overarching law is the United States Constitution. So whatever the state does, of course, must also be in line with the Constitution of the United States. So, of course, when the Constitution first came out, it just applied to federal law enforcement action. But of course, through later cases, and then we also learn how about the creation of judicial review. It gave the courts the power to review the acts of both the legislative branch and the executive branch. So in doing so, it gave them the power later on to determine that, okay, we're going to create the Congress after the slave, what we call the post-slavery amendments, the 13th Amendment, and then of course the 14th Amendment. Those are created, one, to end slavery, which didn't really end it, it just changed it. The 13th did, and then the 14th Amendment, it was created to now kind of give further protection of those people that were just freed from slavery from the states. So it said that the Constitution also applies to acts of the state. So before that, it only applied to acts of the federal law enforcement. So the state could still kind of do what it wanted to because they could say, well, that Constitution doesn't apply to me. But the 14th Amendment says, yes, through incorporation, we're going to apply those first 10 amendments to the states as well. So, of course, the book talks about different theories of incorporation and stuff like that. So read that as well. Fundamental rights, also due process and stuff like that. So there's a due process clause in the Fifth Amendment. It's also included in the Fourth Amendment to apply to the states. There's an equal protection clause in the Fifth Amendment, and through the 14th Amendment, the same rule, the same equal protection clause applies to the states as well. So that's just how the Constitution works. So I want you to know how America is structured and how America does business. So if you know that, you know a lot about even the electoral process and what's going on now. So the states are nothing more than small subsidiaries, or they're their own corporations. So you have the state corporate entity that is now joined with these other 49 states to say, okay, we're in business together. We have to do what we have to do to hold everything together. We're in partnership, and we have the federal government who we're joined to form. So that's kind of how it works. And the federal government in and of itself is the big corporation. So that's how American civics works. So I don't want to go into a big history lesson over it, but you have to understand that to kind of understand the court structure on both levels and how sometimes there is a back and forth between the federal government's ability to act, and then you have what they call states' rights. So even now, that's what kind of separates political parties. There are certain political parties that, like the Republican Party, they're conservative. What conservatism means is they want limited interaction from the government. They don't. In other words, we want to be free of government interaction, and we want to make our own money. And that's why they always say pull yourself up by the bootstraps, because that's their argument. Because they did, of course, even though they didn't. No one in America has pulled themselves up there by their own bootstraps unless they committed a great crime, got away with it, and got rich. There's literally three ways to get rich in America: sell out, commit a crime, or get government help. So everybody's rich because of one of those three things. So the Democratic Party, of course, is more about government assistance. So a lot of the things that came out of the new Democratic Party, because sometimes they kind of shifted, it's been all about government assistance. So they're not conservative. They don't believe in federal conservatism. They believe in the government actually coming in and helping and giving of itself to help bring people up. And some would argue that sometimes that relying on the government is what can hurt minorities sometimes. I say it's kind of in the middle. I think if people have been disenfranchised purposely by law for a long time, I believe the government should help them out a little bit. And then once they get to an equal footing, then because everyone else had a head start, then at that point, now it's about now they have bootstraps in which to pull themselves up. But that's just my opinion. So I want you to understand how it works in your reading of chapter 3 and chapter 4. Next week, actually was tomorrow at 7 a.m., chapter 5. Now we're going to start talking about the different players in the courthouse, the people that have something to do with everything that happens in the courthouse. We call it the courthouse working group. So we're going to start talking about prosecutors and what their job is. Of course, this book is really good about, how the prosecutors were created and how it happened. So they're going to talk about that. So read chapter 5. I also lectured on chapter 5. So listen to my lecture. And then we'll meet next week at another Zoom on the 15th, and we'll discuss chapter 5. And so you don't have your first quiz. And of course, the first quiz isn't until September 22nd. And we would have had let me see. We would have a Zoom like 6 days or so before that. So we will talk about chapter 6 and do kind of a review and talk about what the quiz is going to consist of on the 16th. So are there any questions at this point in time? I guess not. No one's going to say anything. So that's it. I'm going to let you guys go. Anybody else want to, if you have any issue about whether or not you were checked in or I got you, let me know now. Speak now, forever hold your peace. All right. Well, we're going to forever hold our peace. You guys take care. Hello?
You too.
Thank you.
All right, y'all be good. Take care. I'm gonna post a link to this discussion. It's gonna come up tonight, so you'll see it probably about 20 or 30 minutes. Y'all take care.
Thank you.
All right.
Thank you. Have a nice evening.
Bye.